Hello and welcome to another edition of Coffee Talk with attorney Brian Lerner. In this particular episode, I'd like to talk a little bit more about the no contest clause, because if any of you have seen a trust or a will, and for sure if you had an attorney prepare it, there are always provision in there which essentially says if anybody who's a beneficiary to this particular trust or will contests this will or trust in a court of law, then they forfeit everything that would have been given to them. That's basically the essence of a no contest clause. So there's been so much litigation on this particular cause over the years, it's incredible. However, based upon when certain events occur will determine when and if it's enforceable. So the first thing to look at is whether or not there's a direct contest or not, because if there's going to be a no contest clause, you have to know if there's a direct contest. So basically the direct contest to the trust or the will essentially is a pleading or a legal brief that is filed with the court by the beneficiary which alleges the invalidity of the particular instrument based upon, and it has to be based upon one of these several grounds here: forgery, lack of execution, lack of capacity, menace, duress, fraud, or undue influence, and then and so forth. So and then there's different ways of stating the beneficiary should be disqualified because of various reasons and so forth. So you want to look and first determine whether or not there is a direct contest. Now, assuming there is, then of course you have to determine whether or not probable cause exists in which to bring the no contest clause. And we're talking now realistically about cases that have been filed after 2010. Okay, and by filed I mean the trust itself became irrevocable after 2010. And normally a trust or will, once the grantor dies and once certain things happen, it becomes irrevocable, so it can't change. So probable cause must exist in which to file the will contest, or else it'll be thrown out and you, the beneficiary, could lose what is bequeathed to you. So basically the probable cause exists at the time of the filing if facts known to this person would cause a reasonable person to believe there is a likelihood that the requested relief will be granted. Now, keep in mind, this doesn't mean that you file it if you have a scintilla of belief that something was wrong, and then it turns out, 6 months later or a year later, after doing tons of discovery and depositions and interrogatories and getting all kinds of subpoenaed information from banks and accounts, that you were right. That is not probable cause. Probable cause means at the time you file it, there is something to indicate that something's wrong, okay, that there was fraud or duress or whatever it is. And so, it has to be more than just a mere possibility. Even though you don't have to have all the facts with you at the time, it does need to have a sufficient amount of probability, more than just a scintilla of evidence that you will succeed. So, while there is the possibility after it's filed of doing discovery and of getting the information to actually prove what's going on, again, you need to have some basis in which to file it in the first place, and then that would satisfy the probable cause element. So, if you have questions, if you like the video, click like, subscribe, and also you can call my office anywhere in California for a free consultation. I'll let you know what can be done, what the costs are, and so forth. And I also do consults by telephone if you can't make it to the office or are not local. Okay, more in the coming videos.